In this audio, I'm going to discuss B-1 for personal and domestic employees filed at a US consulate, US embassy. In other audios, you will hear me discuss about the B-1. The business visa permits you only to do legitimate business activities. However, this visa, where you would be requesting B-1 status for a personal and domestic employee, you would be coming to the United States temporarily, and you are eligible to work in the United States while in B-1 status for personal and domestic employees. This is huge because B-1 business visas do not typically permit you to work. Once you start mentioning the word work to a consular officer, they by default will probably deny you because you're not permitted to do that. It does not fulfill the requirements of a business visa. But as a business visa requesting for personnel and domestic employees, work is permitted. So let's go through what categories would permit somebody to apply for a B-1 for personal and domestic employees. Domestic and personal employees includes, but it's not limited to, housekeepers, chauffeurs, cooks, housemaids, butlers, valets, footmen, gardeners, nannies, au pairs, babysitters, caretakers, and paid companions. You can either seek admission at the same time as your employer into the United States, or you can follow your employer, meaning the employer is already inside the United States and now you're going to follow them and then commence working for them once you are inside of the United States. This application would be presented at the consulate at same-day adjudication on the assumption that you have been approved. Then once the consulate issues the B-1 visa into your passport and they will annotate domestic personal employee, then you are permitted to come into the United States and work for that employer. Once you are admitted into the United States, then you would apply for your EAD, your employment authorization document, filed on an I-765. And then once you receive that, it's permitting you authorization to work inside the United States as either a personal or domestic employee for the employer mentioned on your B-1 application. So here is the huge difference in what you are permitted to do. First of all, you can work, you can apply for your work authorization. You're not permitted to do those things under a regular business visa. But unlike the subsets of the B-1 visa category, where salaries, wages, or remuneration are not permitted to be paid whilst you are inside of the United States, they must be paid from abroad. Under the B-1 status for personnel and domestic employees, you may be remunerated from inside of the United States because you have a valid work authorization. You're essentially working inside the United States. The word work would be a huge trigger for a consular officer if they are adjudicating a temporary visa such as a business visa. You're not permitted to work, and it causes many people problems when they go for interviews. And I have discussed this in other audios that go ahead and listen to them. There's free and there's paid. Whatever you want to listen to, you can find out, the subject matter that interests you and you can listen to it. But if you mention the word work, because you now wish to enter as a domestic or personal employee, then that would not be a ground to obviate you, preclude you from obtaining the B-1 visa, because you're permitted to do it under this category of a B-1 business visa. Under this B-1 category for personal and domestic employees, I'm not going to go into, obviously, documentation in detail here, but I will touch on a few things. There should be an employment contract in place between the employee and the employer that you will be working for. Typically, the employer must provide medical insurance and agree not to withhold their employee's passport. It's kind of an odd one, this visa, because different consulates have different nuances in their requirements for this type of a visa. So who is not eligible for this visa? So personal and domestic employees of lawful permanent residents, LPRs, someone who has a green card, they are not eligible for B-1 status. And the reason behind this is the employing LPR is a resident of the United States, meaning they're going to be permanently inside the United States. The basis of this is the temporary visa. So if the employer is a green card holder or someone that holds LPR status, then they are not permitted to have a B1 employee as a personal or domestic employee. There are essentially three subsets of individuals that are permitted to bring domestic employees to the United States under B1 status. The requirements are they're essentially the same, but there's some nuances. So I'm going to try and cover as best I can in this audio. Personal and domestic employees of US citizens who reside abroad. So there's many US citizens that do not live inside the United States. So this subset is available when the US citizen employer maintains a permanent home or is stationed abroad, that's outside of the United States, but will visit the United States temporarily. And here are the requirements for this subset. The employee has a residence abroad, so abroad is outside of the United States. The employee has no intention of abandoning this residence. The employee demonstrates through statements from previous employers that he or she has at least 1 year's experience as a personal or domestic employee. So, for example, if you're requesting to enter the United States as someone's gardener, you should have at least 1 year's experience in that role previously. The employee also must be able to show that they were employed abroad by the non-immigrant employer as a personal or domestic employee for at least 1 year prior to the date of the employer's admission to the United States. Or that the employer can demonstrate that while abroad, outside of the United States, he or she has regularly employed a domestic servant in the same capacity as what they're requesting now for the personal or domestic employee. So there's an or there. You might want to replay this back. Now, if you're going for the latter, you want to remember that the employer-employee relationship must exist prior to the commencement of the visit to the United States. So it's not a case where you wish to bring somebody over as your employee and you have never commenced with the personal or domestic arrangement. So just be mindful of that. Officers will deny you. They're going to look at, do you qualify for the requirements? A little bit about remuneration for the employee. The employee should be paid the minimum or prevailing wage, whichever is greater, for an 8-hour day, workday, and provide other benefits normally required for US domestic workers in that area of employment. The next subset is personal and domestic employees of US citizens on temporary assignment in the United States. So this subset is available to a narrow class of individuals because of the strict requirements, which are the following. The US citizen employer must be subject to frequent international transfers lasting 2 years or more as a condition of the job as confirmed by the employer's personal office, and must return to the United States for a period of no longer than 6 months. The personal or domestic employee must have no other employer in the United States besides the US citizen. There must be an employment contract that is signed and dated by the employer and employee. The employer must provide, and the employment contract must confirm, provision of free room and board, as well as a round-trip airfare to the United States and return abroad. The employment contract must provide for at least the minimal or prevailing wage, whichever is greater, for an 8-hour workday. The employment contract must also reflect any other benefits required for US domestic workers in that area. And in the event of termination, the employer must provide at least 2 weeks' notice of their intent to terminate. Just a note, it's always required that the employee has a residence abroad and that there is no intention of abandoning this residence, so that when you go to your consulate interview for B1 status as a domestic and or a personal employee, you must be able to show that you have a residence in your home country, that you will not abandon it. You're showing residence by a mailing address, either you have a lease agreement in place or you have a mortgage on the property, that there is mail going to this property, that you have, for example, a utility, evidence of a utility statement that is under your name going to the property. If you are living at home with parents, then I would advise you can listen to other audios under tourist visa, business visa, because I go through all of this. But you have to show this residence, because otherwise, if you don't, you will be denied. The third subset is personal and domestic employees of foreign nationals who hold non-immigrant status in the United States. So certain foreign nationals who themselves hold non-immigrant, that's temporary status, in the United States are also eligible to sponsor personal and domestic employees for B1 status. The foreign national employer must hold one of the following non-immigrant statuses. So this is the employer now. So the employer holds non-immigrant status themselves. And these are the permitted non-immigrant classifications that an employer must have in order for them now to sponsor a personal and or domestic employee. They must have either a business or pleasure visa, B category, E, investor or treaty, F, international student, H, professional in a specialty occupation, a nurse in a shortage area, agricultural worker, temporary worker or trainee. So there's lots of categories I'm listing out here very quickly. It's not just an H1B, it's H2A, H2B, H3 I'm talking about as well. I, worker in foreign media, J, trainee, L, intercompany transferee, M, international vocational student, different to the M1, which is academic, O, an individual with extraordinary ability, and an individual supporting individuals. So you can also have support personnel. P, an artist, entertainer, whether a member of a reciprocal exchange program or not, and an artist with a culturally unique performance. Q is a participant in international cultural exchange program. So if you're an employer in one of those categories, you can sponsor a domestic and or personal employee to come into the United States either at the same time as you or follow you, and they can be admitted as a B1 domestic personal employee and they can work for you. So this is a very useful visa to know about, to understand about, and it permits you to do work. You can apply for a work authorization. You can come in many different positions. I've listed out just a few. There are 3 subsets and I have delineated who the employer is.